know there are a number of parties. We're going to begin with the state of Texas in 23-60069. Mr. Davis.
Thank you, Chief Judge Richman, and may it please the court. EPA often misses the deadlines that Congress set for it in the Clean Air Act. Here it missed its deadline to approve or disapprove Texas's State Implementation Plan, or SIP, by several years. It then disapproved that plan based on data, guidance, and modeling tools that were developed after Texas met its deadline to submit its SIP revision. That approach didn't just violate the Act's deadline for EPA action on SIPs. It violated the statute's core structure of cooperative federalism, this court's precedent, and fair notice principles under the Administrative Procedure Act. If I could start with that final point on notice, we mentioned in the brief the example of a law professor who gives an exam and then grades it and faults students for not discussing a Supreme Court opinion that was handed down after the exam was administered. In that example, just as the students couldn't pass that exam, the state here couldn't avoid federal regulation through a FIP, which is what happens after a SIP disapproval, because they didn't have a chance, Texas didn't have a chance to look at that information that EPA released later. And so what TCEQ did, that's the Texas environmental agency that prepared Texas's SIP, was look to the best available data at the time. That included information provided by EPA. And for instance, the 2017 Notice of Data Availability that came out before the SIP revision deadline, and also the March 2018 guidance document. It submitted its SIP on time, and then more than 2 weeks after the deadline for SIP submittals, EPA released another document, the October 2018 maintenance receptor guidance that introduced a new condition on identifying maintenance receptors, and then also came up with new modeling platforms, which are referred to in the briefing as the 2016 V2 and V3 platforms. And we know that EPA disapproved Texas's SIP based on that new information. If we look at page 9359, in the third column, EPA is talking about its basis for disapproving Texas's SIP. It starts with the phrase, in the 2016 V3 modeling. If we look 5 pages later at 9364 in the top of the first column, we see EPA faulting states for not meeting the terms of various memoranda it put out. It identifies 2, including the October 2018 post-SIP deadline memorandum about maintenance receptors. Now, in its briefing, EPA says, oh, well, that might be true, but there are other bases for disapproval. The problem with that is those arguments are post hoc rationalizations, and under settled precedent, those are at best for EPA irrelevant, and at worst, they're another indication of arbitrary and capricious action by the agency. And if I could move to a second point about cooperative federalism, that's at the core of the Clean Air Act, especially Section 7410. And EPA treated the SIP stage, which is what that section governs.
Let me ask you a question. Since you were talking about tardiness of EPA, would your argument be at best, if they change the rules, so to speak, that the agency should have reviewed the Texas application under what would have been applicable had it been timely and so forth? So would part of your relief then be sending it back or a determination based on that?
That's correct, Judge Stewart. And we pointed out in the briefing that the Clean Air Act provides EPA with a tool to address the new data it says is relevant, and that's to issue a SIP call. What it can't do is judge a SIP based on information that wasn't available to the state at the time. That essentially, as I've just mentioned, would eliminate the SIP stage. And this court's precedent is clear on that. If we look at Luminant from 2012, for instance, in Texas versus EPA from 2016, the court focuses on K3 of Section 7410 and reads that provision to say EPA has a ministerial function at the SIP stage and that it has to defer to the state's choices. EPA disagrees with that expressly in the final rule at page 9375, but that's directly contrary to this court's precedent. One other thing I wanted to mention is my friends on the other side have characterized the Texas SIP as a do-nothing SIP. That's a nice catchphrase, but it's not accurate. The Texas SIP is a very long document that imposes controls of all sorts on sources. What we're talking about here is a revision to that SIP. And on page 2 of EPA's March 2018 guidance, EPA stated that states could demonstrate compliance with the good neighbor provision requirements by relying on existing components of the SIP. But the revision at issue here is also a substantial document. It's over 700 pages of technical demonstration, very different from what we see in other cases, such as the Westar Energy case from the DC Circuit from 2015 rather, where a state submitted a single page to try to satisfy its obligation. We're at the complete other end of the spectrum here. And then the final point I would make is that EPA disapproved the SIP based on non-statutory factors, again, in violation of this court's precedent. I think we see that most clearly through EPA's imposition of the 4-step framework that it developed at the SIP stage and its use of the 1% threshold, which is meant to be just a screening tool, but EPA used it as an indicator of significant contribution. We see that in the final rule at page 9342 in the second column and in the proposed rule at page 9833 in the third column. I see my time has expired.
May it please the court, Stephen Gidiere for Texas Industry Petitioners. I'd like to pick up where Mr. Davis left off. EPA's disapproval of Texas's plan is unlawful because EPA used non-statutory factors to judge that plan. EPA's 4-step framework, it's not in the statute, it's not in any regulation, it's not a requirement for state plans. It's something that EPA developed for federal plans. The record here is undisputed that EPA used the 4 steps to judge Texas's plan, used it as the yardstick, as the measure of compliance. EPA said that Texas must substantially justify any deviation from the framework, that Texas must counter EPA's 1% threshold at step 2 with substantial evidence. And it judged Texas's maintenance monitor approach as compared to or in comparison to EPA's method. This court's precedent is clear. EPA cannot disapprove a SIP using non-statutory factors. The court has said it over and over again. In Luminant 2012, EPA used a similar source rule to disapprove Texas's pollution control permit program. The court said, no, you can't do that. That's non-statutory. In Texas 2012, EPA used a drafting style on Texas's flexible permit case. Again, the court vacated that disapproval. In Texas 2016, same result when EPA tried to use a source-specific analysis. This case falls right in line with those prior cases, and the result should be the same. The disapproval should be vacated. It doesn't matter that interstate transport of ozone is involved. The Supreme Court has been clear about this. Nothing in the Act differentiates the good neighbor provision from any other provision of the Act. That's at E.B. Homer at 509. I think a helpful comparison to those other cases is the Luminant 2013 case. That was the case about EPA's disapproval of Texas's SIP on startup and shutdown emissions. Judge Stewart, that was your case. That case was different here because there EPA was using statutory factors that were expressly set out in the statute to judge Texas's SIP. Those factors were listed explicitly in 7413E, and there was an express statutory definition of emission limitation that EPA applied in that case. The court discussed that at page 846, but that's not what we have here. EPA is...
What's the bottom line relief Texas is seeking? Is it a grant, of course, of the relief you seek, but is it a plenary determination from this court that was submitted, was approved, or a plenary determination on the law and send it back to the EPA with a set of rules as to how to scrub this, or which? You follow me?
The relief we're asking for is to vacate the disapproval. That will mean the matter is back before EPA. We don't think that remand without vacature is appropriate as the government has asked for, because we don't think that they can simply re-explain the disapproval. We'll think there have to be additional proceedings for that to take place. So we're asking for vacature of the disapproval. We're not asking the court to direct the agency to approve it. I don't think the court can do that.
Right. But you're asking for vacature and send it back, but with sort of a pathway to where it would be inescapable that when it went back to the EPA, they'd have to approve it, though, right?
Well, I think they would need to then approach Texas and SIP on its own terms, not start with their own bias in their four-step framework, not compare it to the four-step framework, but review it on its own terms.
Okay.
I would also note that EPA's four-step framework is not in any regulation. They do have regulations with respect to the 2015 ozone SIPs. They do have regulations about interstate transport, but we cite those in our brief at page 38. But there's nothing in those regulations that have the four-step method in it. Now, EPA looks to the EME Homer case as support for its position, but EME Homer only addressed federal plans. It didn't address state plans. There were no SIPs at issue in that case.
Why wouldn't the reasoning be why wouldn't the reasoning be instructive, albeit it's federal versus state, but why wouldn't the reasoning be at least instructive? Is that enough of a distinction because it was federal and not state?
Well, I think this court has recognized that the state panel recognized that the four steps is one reasonable way to look at the good neighbor provision, but it's not the only way. And so Texas should be able to use its own method, which it did, not treat the 1% as controlling, to use a weight of evidence test, which this court has said in Texas 2020 and the BCCA appeal group case are valid ways to look at ozone contribution and to make that judgment and make a reasoned decision about that. There's a substantial record developed by Texas, and they made their own decision. EPA doesn't need to second guess that. In addition to EME Homer, there is no case that discusses the four-step framework with respect to state plans. All of the cases that EPA cites involve the four-step framework in federal plans. I think the 10th Circuit's decision recently in the Wyoming case was instructive, where they discussed the fact that EPA has more discretion with federal plans and less discretion when it comes to SIPs. They have to defer to the state's judgment. Now, we also raised a number of technical issues in our brief. EPA had some technical complaints with Texas's SIP, but the court doesn't need to reach those issues because EPA used non-statutory factors at the beginning. Its disapproval should be vacated. And we did point out in our brief how many of those technical issues EPA acted arbitrarily and capriciously, like using ballpark estimates to judge Texas's modeling when EPA itself admitted that those ballpark estimates were not a defensible basis for any Clean Air Act action. Again, the court doesn't need to reach those issues because the threshold issue is dispositive. Now, a few points on venue that I'd like to make. I know the government will address that. The motions panel got it right. This case belongs in this court. Again, this court's precedent is controlling. The SIP disapprovals here are like the SIP disapproval in Texas 2016 and like the exemption denials in the recent Calumet case. How EPA published them is not dispositive. It's the legal effect of the action, and the legal effect of the disapproval of Texas's SIP is only on Texas and Texas sources. It's not the downwind effect. It's not the practical effect. It's the legal effect. The nationwide scope or effect exception doesn't apply, just like it didn't apply in Texas 2016 and it didn't apply in Calumet. We know that EPA evaluated the contents of each state plan on its own merits. And with respect to Texas specifically, EPA says in its brief that it disapproved Texas's SIP for two distinct reasons, and both of those are specific to Texas. Texas's weight of evidence approach and its maintenance monitor approach. Both of those are unique to Texas. Both of those were addressed by EPA in a Texas-only technical support document that's in the record at R6-2. I don't think EPA did that for any other state. The Texas reasons are in there. Now, EPA says in this 28J letter that it filed on Friday that venue should go to D.C. because EPA's core determinations concern nationwide issues of interstate pollution, not specific to particular states. That argument is completely contrary to the record here and what EPA said in the record. It sounds like an argument about EPA's federal plans, about its trading program, but that trading program is not an issue in this case. We do have petitions over EPA's Texas federal plan pending in this court in another case. It's 23-60300, but that's not this case. On the nationwide exception, this case is like Calumet. The 4 steps are not the determination. It was EPA's application of those 4 steps. It was the determination, and that was specific to Texas. Thank you.
May it please the court, Sarah Izfar for the United States. I'll be sharing my time with my DOJ co-counsel, Ms. Lee. I'll speak for 10 minutes and will address why venue is proper in the DC Circuit and the scope of EPA's general SIP review authority under the Clean Air Act. Ms. Lee will address the remaining arguments, including why EPA reasonably disapproved Texas's plan on its own terms as flawed and inadequate. With me at counsel's table are Rosemary Caban and Daniel Schramm from EPA's Office of General Counsel. Before I turn to venue, I want to step back for a moment and highlight 2 important points that are critical to understanding all of the issues in this case, both on venue and on the merits. The first is that this is about EPA's evaluation of state implementation plans that were prepared to comply with the Good Neighbor provision. That means that state plans shall contain adequate provisions to prohibit amounts of pollution which significantly contribute to non-attainment or interfere with maintenance by any other state with regard to national pollution standards. So unlike other SIP requirements that this court may be familiar with, which require states to look at their in-state pollution and how it affects in-state national standards, this provision requires states to look at their effects, their pollution, and how it affects other states and other states' maintenance of healthy air national standards. That makes that difference makes the analysis that states conduct here very different. The second overarching point that states have to grapple with is the pollutant at issue here, which is ozone. It causes serious health effects like asthma and heart attacks. Historically, ozone has been regulated by looking at its precursor pollutants like nitrogen oxide. That's because ozone isn't emitted at the source. It's not emitted by factories. It's created through complex interactions in the air between nitrogen oxides and other chemicals which combine in the air to form ozone. And ozone doesn't stay local. It travels hundreds or thousands of miles. So as EPA has recognized, the Supreme Court in EME Homer has also upheld, and no party here disputes, ozone pollution presents a collective contribution problem. You'll hear us saying that a lot today, and that's because that is the important thing that all states need to grapple with and that all states fundamentally did not grapple with here. Due to the vagaries of the wind, contributions from many upwind states combine to cause ozone problems in downwind states. You can see the national scope of the problem facing the states and EPA on page 72 of our brief, which has a map showing the many linkages among many states that span the entire country. With that backdrop in mind, turning now to venue, the interstate nature and the collective contribution problem addressed by the Good Neighbor provision, or the Good Neighbor submissions here, require that the case be transferred to the DC Circuit. In the Clean Air Act, Congress specified that actions of national applicability and those based on determinations of nationwide scope or effect must be reviewed in the DC Circuit to maintain national uniformity and consistency. Our arguments about national applicability are in our brief, and because my time is limited today, I'd like to focus why the disapproval was based on one or more determinations of nationwide scope or effect. In evaluating whether the states complied with the Good Neighbor provision, EPA had to make multiple determinations of nationwide scope or effect. These are listed in our response brief on page 69. They're identified in the response to comments in the record on page 392 and in the disapproval on pages 9361 to 79. They flow from EPA's evaluation of the state's use of nationwide modeling to analyze the collective contribution problem caused by high ozone. Whether you're looking at the state's preferred modeling or EPA's modeling, you're looking at nationwide modeling. And that's because that's what's needed to evaluate the formation and dispersion of ozone across state lines and to define good neighbor obligations. The states attempt to isolate and minimize their contributions to this collective problem and characterize the issues in this case as having only local scope or effect. But the nature of the problem that the states in the first instance and EPA in reviewing the state's plans must address under the good neighbor provision requires determinations of nationwide scope or effect.
Push back on the argument made is they don't seem to dispute that there's nationwide or national implications, but the argument made to the motions panel, which we're not bound by, but the motions panel disagreed with you in so many words as to say, yes, it's national, but if your approval or disapproval of the plan is based on ingredients that are indigenous to the state, then that sort of shifts the calculus, so to speak. That's the motions panel found that, at least the split panel found that dispositive. So point to more specifically beyond just that argument, what is it? I know you did the 28J from the Sixth Circuit, they looked at the factors and so forth, but address more specifically why the local Texas or Louisiana, Mississippi factors, if they're inherent in the approval or disapproval, why do they not alter the calculus enough to where venue shifts locally as opposed to more globally?
Yes, Judge Stewart. So I have two responses. The first is I would direct you to the plain text of the statute, which says that local or regional actions which are based on determinations of nationwide scope or effect belong in the DC Circuit. So just because the court determines that a SIP is locally or regionally applicable, that doesn't mean that the venue exception doesn't apply. If that were the case, the venue exception would never apply, and Congress did not create a null set. But the second point is that I want to push back on this narrative that there are binaries like local and regional determinations and national determinations. They can't name the local determinations they made. They're talking about Texas's contributions to other states. And I'll give you an example. So Texas, even under their modeling, contributes pollution to Colorado, but other upwind states also contribute to Colorado, and they can't assess their own significant contribution without considering the relative contribution of other upwind states, Colorado's own contribution. So when we're talking about how ozone works in the interstate transport context, even their determinations, even the state's determinations, are nationwide in scope.
So let me ask you one follow-up. Undoubtedly on the DC Circuit's docket, there are innumerable appeals that go to it, administrative, regulatory, et cetera. And there have to be statutes which make it clear that DC Circuit is the only place that it can be, right? So if you're making a textual argument, help me with how the language in this statute is like the many others, where the terms of the statute just make it clearly only the DC Circuit.
So just to be clear, I don't think the venue determination about whether the action is based on a determination of nationwide scope or effect is purely a statutory question. It's not that all good neighbor actions go to the DC Circuit. It's just that in this case, we're talking about, it's a fact-specific inquiry. We're talking about ozone, which travels hundreds of thousands of miles. We're talking about the determinations that were made, the very specific factual determinations that were made. And because those determinations were based on determinations of nationwide scope or effect, that's why we believe venue is appropriate in the DC Circuit. And this Clean Air Act venue provision is very unique. Congress's intent here was to provide for centralized review. And what's happened here with 8 different federal circuits hearing the exact same arguments in many different forums and potentially reaching conflicting results is exactly what the statute was intended to prevent. This is the first merits hearing, and this panel can send a very clear signal that venue belongs in the DC Circuit. I see that my time is limited, so I want to speak very briefly on cooperative federalism. While the court should transfer this case to the DC Circuit, if it reaches the merits, the court should uphold EPA's disapproval. My co-counsel, Ms. Lee, will address the specific technical flaws, so she'll answer all of your modeling questions. But I just wanted to talk briefly about EPA's SIP review authority under 42 USC 7410 K3. Under EPA's statutory obligation to review state plans for consistency with the Act, it's EPA's role to determine what the applicable requirements are and whether the applicable requirements are met. It then falls on states to drive the regulatory process. And in the context of the Good Neighbor provision, EPA's independent review is especially limited. The Clean Air Act relies upon a partnership between states and the federal government who share a singular goal, attainment of the NAAQS. That is what the cooperative federalism framework is all about. It's all about the states and the federal government working together to attain the NAAQS. So the states are supposed to drive the regulatory process. But if the car is stalled, the statutory deadlines in the Clean Air Act are set to ensure that the journey still continues. They're not meant to ensure that the state always stays in the driver's seat. That is why when EPA misses a statutory deadline, there's one remedy: bring a deadline suit and put them on a court-ordered deadline. I see that my time is out, and so I will continue the rest of my remarks in the following argument. I see the rest of my time to my co-counsel, Ms. Lee.
I have a follow-up question to what your co-counsel just said.
Yes.
She said the remedy was to bring a deadline action against the EPA. So you get a deadline action, so what does that do to the substantive review of the SIP plan?
So, Your Honor, what my co-counsel, Ms. Izfar, was saying is that if EPA misses a procedural deadline under the Clean Air Act, the remedy provided is for the party to bring a district court deadline suit to compel EPA to take action by a specific date. That's what the amici groups, the environmental NGOs in the upwind states did, and compelled EPA with a consent decree deadline to take final action on the SIPs at issue under the disapproval by January 31st, 2022. And EPA met that deadline by doing so.
But then what data can be considered once a new deadline is set?
Correct. So the data that EPA may consider is the best available data that's available to EPA at the time that it's making its decision. And so at the time that EPA was making its decision, there was more refined modeling and more up-to-date data available. And so EPA lawfully and reasonably considered it because that data is relevant for estimating ozone concentrations and contributions, which is particularly relevant in the Good Neighbor context because it specifically asks whether emissions will significantly contribute to non-attainment or will interfere with maintenance. So this forward-looking provision makes it particularly relevant for EPA to consider the most refined modeling and the most up-to-date data, as that provides for the most accurate and estimation of what the ozone projections will be in the future. However, I just wanted to step back and note that there are multiple bases for EPA's disapproval here, one of which was under the updated modeling that the 2016 V3 modeling that petitioners explained in their section. But another basis for EPA's disapproval, as reflected throughout the record, is under Texas's own plans. Remember, under the Good Neighbor provision for the 2015 ozone NAAQS, the goal is to equitably distribute the cost of ozone pollution to those upwind states that collectively contribute to ozone pollution problems downwind by asking those upwind states to eliminate those emissions that will contribute significantly to non-attainment or interfere with maintenance. Here, Texas's own plan, which used its own version of photochemical grid modeling that EPA agrees is the best state-of-the-science tool for estimating ozone concentrations and contributions, show that Texas did contribute to downwind ozone pollution problems, including in Colorado and among other states. So plainly, under the Good Neighbor provision, Texas should have further evaluated its contributions by looking at its sources and their emissions to determine what amounts of its emissions will contribute significantly or interfere with maintenance. But Texas did not do so. Instead, Texas conducted different analyses to try and negate the findings of its own photochemical grid modeling, and those analyses were either utilizing rudimentary tools or based on technically unsupportable arguments. For example, or actually, this is what Texas did. Texas presented an alternative definition of significant, defining it as a persistent and consistent pattern of contribution on high ozone days. EPA reasonably explained in the record as to why that failed to comply with the good neighbor provision. And to reiterate what my colleague Ms. Izfar explained, this is not a state-specific inquiry that Texas conducted. In fact, the states of Louisiana, which is going next, and the state of Arkansas also use this definition. And for all three states, EPA reasonably explained why that definition of significance failed to comply with the good neighbor provision for three independent reasons. First, Texas provides no standard for when this pattern is established and zero rationale for why this pattern is relevant for evaluating good neighbor obligations. Whether a state has a good neighbor obligation, whether a state has an ozone pollution problem can be driven by as few as 4 high ozone days per year. So even under Texas's flawed interpretation of EPA SIP review authority, Texas's definition of significance fails to comply with the good neighbor provision because A, it doesn't explain when this pattern is established, and B, it doesn't explain why this pattern is relevant for evaluating good neighbor obligations when a downwind state's ozone pollution problem is not at all dependent on this pattern. But second, even if contributions on numerous high ozone days was relevant to the inquiry of what a state's good neighbor obligation is, EPA reasonably explained that Texas's own analysis sufficiently accounted for numerous high ozone days because Texas calculated its own contributions by looking at 5 to 10 high ozone days, which is more than the necessary high ozone days for a downwind state to have ozone pollution problems and exceed their NAAQS.
Counsel, with respect to the kickoff argument by Texas that the four-step framework is illegal, arbitrary, and capricious, and that EPA is not allowed to refer to non-statutory factors, how do you address that argument?
So, Your Honor, EPA did not disapprove any state's plans for failing to adhere to the four-step framework. That is provided in the record, RTC 430, and explained in our brief, pages 90 to 92. And indeed, the record reflects that EPA fully evaluated each state's submission, including Texas's four-step analysis by also at step 1, recognizing that Texas, under its step 1 analysis, identified downwind receptors. Texas, like EPA, at step 2, used 1% as a screening threshold, which all it simply does is identify those upwind states that are part of the collective contribution problem. Therefore, under the good neighbor provision, those upwind states are then expected to further evaluate their contributions by looking at its sources and their admissions to determine what amounts will contribute significantly to non-attainment or interfere with maintenance.
Okay, I understand what you're saying about Texas,
Right.
but what about the four-step plan that EPA used that Texas is saying was legal?
Well, EPA
What's
didn't.
the authority that allows the EPA to do that?
Well, as an initial matter, Your Honor, EPA's disapproval isn't based on the four-step framework. It's based on Texas's own plan failing to comply with the requirements of the good neighbor provision. So even looking at Texas's plan and the organization that they put forward, Texas's own modeling showed that it contributed to downwind ozone pollution problems. So under the good neighbor provision, then they're expected to further evaluate its contributions. What they did at their own step 2 is to define significance in a way that is not relevant or not explained. Their explanation, they provide no explanation as to why their definition of significance is relevant for evaluating good neighbor obligations, which seeks to allocate the cost of ozone pollution to those upwind states. And so even under their framework of they're of significance as a persistent and consistent pattern of contribution on high ozone days. It does not comply with the good neighbor provision. But even if that standard was relevant, as I explained, Texas's own analysis sufficiently accounted for numerous high ozone days, such that even under their definition of significance, they should have proceeded to consider emissions reductions, because their contributions over 5 to 10 high ozone days, which is more than the number of ozone days necessary for a downwind state to have ozone pollution problems, show that they contributed, were above the screening threshold, and therefore was part of the collective contribution problem affecting downwind states, including Colorado's ozone air quality.
2 questions.
Yes.
Follow up to Judge Scholer. Are you saying EPA did not disapprove Texas based on the 4 steps? Is that what you're saying?
Correct.
Okay. So then what's the EPA's argument on EME? I thought the argument about EME was to say the Supreme Court approved the 4-step factors. They say distinguishable because that involved federal and not state. So you're saying the 4-step, 4 factors is not the principal basis here?
So
Maybe I'm misunderstanding the argument. Maybe me. It probably is.
I'll clarify, Your Honor. Apologies. So what we're saying regarding EME Homer and the 4 steps is that that is an organizational tool that EPA uses in terms of evaluating good neighbor obligations. That has simply been held as reasonable and practicable. But EPA acknowledged that states do have flexibility in determining how they want to organize their data and submit their SIPs for EPA's review. And so EPA fully evaluated any alternative framework that was offered. But whatever alternative framework that was offered still has to meet the good neighbor provision and adequately.
Well, back up to their opening position was this whole matter was dilatory, and so by the time EPA acted, it took into account factors, if not these 4, that they were not apprised of, and that itself was arbitrary and capricious, that the dilatory nature of it, and so they wouldn't have been aware of what the considerations were, therefore they couldn't apply. What's your response to, I think I got the argument he made right, maybe I misunderstood.
Right, so
They don't say you move the goalpost, but they do make an argument to say if you'd done it timely, you'd have to do it based on one criteria, but by doing it later, the evaluation was made based on criteria that Texas was unaware of, and therefore the agency acted arbitrary and capricious.
So 2 responses, Your Honor. First is that EPA's 4-step framework has been EPA's method for evaluating good neighbor obligations for a very long time, since even before Texas and other states submitted their SIPs. It started with the NOx SIP call in Michigan v. EPA in 2000. But second, in terms of EPA's delay, what the record shows and what I spent my time explaining was that even if EPA had timely acted, EPA would have disapproved Texas's plan because EPA fully evaluated Texas's plan on its own merits and Texas's plan using its own photochemical grid modeling, and then the other analyses that they put forward as to argue that their contributions were insignificant actually did not show that his contributions were insignificant and failed to comply with the good neighbor provision. Thank you. No, there are no other questions.
Well, I got one more.
Oh, yes.
I ask counsel opposite. I always like to know what's the relief that's being sought here. There's a whole lot of technical information given to us to understand ozones and so on and so forth and all that. But at the bottom line, the states are asking us to reverse the disapproval by EPA, and I ask counsel opposite, okay, what's the relief? So assuming, arguendo, that we were to agree with them, what would be the remedy? If we remanded, would it be a do-over to the EPA based on the same criteria that was done before? What? I'm not asking you to agree with that as a remedy. I'm just trying to, what's the take on it?
Right, so assuming arguendo then that this court determines that venue is proper here and goes to the merits, then it really depends on what the court's opinion is in remand. EPA would follow the court's direction on remand, but on remand, there's a plethora of options that EPA could take, but the data, the science is clear that states that are covered under the disapproval do contribute to downwind ozone pollution problems, and so therefore under the good neighbor provision they are expected to further evaluate its contributions. So EPA would follow that approach and take the necessary action to ensure that it meets the goals of the Clean Air Act, which is attainment of the NAAQS, and to ensure compliance with the good neighbor provision, which is to fairly allocate the cost of ozone pollution. Thank you, Your Honors.
I could start by responding to the questions about the four-step framework. I didn't hear any answer to where the authority is for that, and there is no statutory authority for it. It's something that EPA has developed and used at the FIP stage, where it has more discretion. We see that in EME Homer, but in footnote 15 of that opinion, the court confirms that even in the good neighbor provision context, the states have a role to play at the SIP stage. Under EPA's argument that I heard just now about remedies for getting it to act when it hasn't acted on time, EPA could always miss its deadline and then generate new data, and that would effectively eliminate the SIP stage. I think that's what we see here. In this record, we see EPA focused on developing a SIP at a time when its SIP disapproval was late. Of course, you don't get to the FIP under the statute until there is either no SIP or
putting aside that, not giving it up, but I know what your argument is. They say, okay, spot that, late, whatever. They say, we disapprove Texas plan based on its own data, et cetera, et cetera, et cetera. So not conceding the other arguments we made, but hone in on that. They say, we looked at what they submitted, it's their data upon which the bottom line approval, even if we were late, even if we did this, even if we did that, at least if I'm understanding the argument, is to say we drill down on the data Texas submitted, and that's the primary basis for disapproval. So help me kind of navigate between.
Sure, Judge Stewart. So that's definitely what they say now in their appellate briefing, and there is some of that in the final rule. But all of those sentences in the final rule say, oh, and we also based it on these other things. And I think the examples that I used in my opening argument, page 9342 of the final rule, page 9833 of the proposed rule, which was adopted into the reasoning of the final rule, that reflects that EPA is using that four-step framework, and in particular step 2, that 1% supposedly screening threshold to be a indicator of significant contribution. And EPA saying, well, Texas's own data just shows that they're wrong, just assumes that that 1% threshold is an indicator of significance, and that's just that's not the case under the statute. The statutory structure also doesn't treat the good neighbor provision any differently, and that again is a point from EME Homer, and that might be my final point. I see my time has expired unless the court has further questions.
Thank you, Counsel.
EPA is now saying it didn't use the 4 steps, but that's not supported by the record. It's over and over again. EPA required Texas to substantially justify a deviation from the 4 steps. It required EPA to counter the 1% threshold. It judged the maintenance monitor approach in comparison to EPA's method. That's at 87 Federal Register 9827. EPA wasn't just organizing its thoughts with the 4 steps. It was using it as the yardstick. Yes, it then used that yardstick to judge Texas-specific facts and to say that in EPA's view, they didn't measure up.
Counsel, moving away from the four-step, EPA in their briefing says that Texas used a faulty method for identifying maintenance receptors, was linked to non-attainment receptors, and failed to assess potential emissions reductions, right? And Texas's weight of evidence analysis was flawed and did not refute linkages. What is your response on EPA's argument in the briefing that the weight of evidence analysis was flawed and didn't refute linkages?
Well, it's that exact point at the end that it didn't refute the linkages. At the end of the day, EPA's assessment was the 1% at step 2 is controlling, and that is not the right yardstick. A weight of evidence test is explicitly permitted under the statute. It is a permissible way to determine ozone contribution. This court said so in Texas 2020 when it said that the 1% was not controlling and that a weight of evidence test. This is additional evidence that Texas considered on top of the 1%. If by discounting the weight of evidence test, what they're really saying, the core of this dispute, is if it's your 1%, you're done. That's their position. Our position is you can look at other information. The state can use a weight of evidence analysis like this court has endorsed to determine no significant contribution. Thank you.
We'll now hear from Mr. Hall for the state of Louisiana.
Good morning, and may it please the court. My name is Jeffrey Hall for Louisiana. After me is Counsel for Louisiana Industry. We'll be talking a little bit about modeling, but I want to make two general points today. One, we agree with Texas. The EPA applied the wrong standard of review, and it asked the wrong question. What it did is inconsistent not only with the standard it cites with approval, but also with this court's precedent and with its guidance memoranda. But two, I also want to impress that EPA completely ignored Louisiana's work, even more so than other states. That reflects a failure to defer, but it also reflects unreasoned decision-making under basic principles of administrative law, and that is an independent ground to vacate the decision, even if the EPA were to get deference under its preferred approach. But I want to address some of the things that Texas talked about up front. So you ask about the remedy. What do you do if EPA applied the wrong standard of review? Well, vacate this. Send it back down and tell them to apply the right standard of review. That is basically dispositive of everything in this case, and not just use the information available at the time. That is certainly a necessary implication of the idea that limited review EPA gets, and that the state gets all of the discretion available. I also agree with Texas Counsel that the most relevant cases here are Texas 2012, Luminant 2012, and Texas 2016. They show that because EPA did not authoritatively interpret the good neighbor provision, but instead promised flexibility, this EPA must have deferred to the state's reasonable interpretations and application. This court's precedent that I just mentioned makes that clear. Even the ADEC case that EPA cites makes that clear. To address something that you said about the standards, the NAAQS is the standard that is textually committed to the EPA. In Texas 2016, the state set the standard, and that standard had interstate effects. So because EPA had not authoritatively set the standard there, under the regional Hayes rule, because EPA had not authoritatively set the standard, the state got to. And that, as I mentioned, the standard had interstate effects. And in that case, it's even more instructive because Texas had engaged in a holistic analysis. EPA rejected it for its preferred modeling with a cost. Again, this court reversed that and said that the EPA could not do that. It had to defer to the state's weighing of the factors and even the setting of that standard there. It was mentioned about EME Homer. I think that is instructive because it shows the discretion available to the federal government in the FIP context, but the state should get that same discretion in the SIP context. When the federal government engages in a FIP, it stands in the shoes of the state. The state should get that discretion when it creates a SIP. I also want to impress that this SIP disapproval should be vacated because if EPA had applied the right standard, it could have obviously come out to a very different result. The Sierra Club 2019 case is very instructive here. In that case, EPA basically applied the Chevron deference, Chevron and the general APA review standard to what the state did. It approved that SIP, and this court affirmed it, even though this court found numerous problems, because it said all the state had to do was consider the evidence and claim that it weighed the factors. If that's sufficient to approve a SIP and for this court to affirm it, certainly all of the work that Louisiana did here is sufficient for EPA to approve that and this court to affirm it. So it obviously makes quite a difference, all the difference in the world. I want to take issue with one of the things that EPA said in the previous argument, that it did not use the four-step framework, and that was not controlling in rejecting the SIPs. It certainly was controlling for Louisiana. We devoted 2 pages of that in our opening brief, 38 through to 39, on a particular point, how EPA said that once there was a linkage in its terms at step 1 and 2, Louisiana had to proceed to step 3, EPA step 3, a control analysis. Now that's just a backwards way to force its particular view of significant contribution on the states, but that was controlling. That is the reason it gave for disapproving Louisiana's SIP. So the four-step framework was very much controlling in that context. And it certainly, in service of that, rejected Louisiana's reasonable interpretation of significant contribution as persistent and consistent. That aligns with the NAAQS, which looks at both a time period within a year, but also over various years. And it certainly is a better view of significant contribution than EPA's, which looks at cost ahead of time. This court the Supreme Court in EME Homer said that when EPA was interpreting significant contribution, it got discretion, but it certainly didn't say that was the best interpretation. And so because the states get discretion, they can use alternative interpretations of significant contribution. And Louisiana's was reasonable. But more importantly, it gave the evidence that it relied on to reach its conclusion. You have all the evidence there. It said it weighed the factors. It said it reached a reasonable conclusion on that. Certainly its work was reasonable. In fact, it's very same work that EPA does in a very similar context. We cited various cases in the non-attainment context where EPA has to look at the downwind contribution from upwind jurisdictions to see whether or not it's interfering with an attainment downwind.
Mr. Hall?
Yes.
It's my understanding, and correct me if I'm wrong, that Louisiana's contribution to ozone was significant under any definition, and it's the government's position that Louisiana was required to analyze emissions reduction opportunities and did not do so. Is that understanding correct?
No, it is not.
Why?
I think what you're referring to is that the modeling showed a contribution above EPA's preferred threshold. And that does not define significant contribution even under EPA's approach. It just prefers that the next step is you look at emissions controls. Whereas Louisiana said, no, we have to look at a holistic analysis, use a weight of the evidence approach, and look at the other tools. And so it looked at the back trajectories, but also wind roses and emissions generally, and the relative contribution between the states. So it looked at a variety of factors. That's a reasonable way to get at the same question. As I was just saying, that's the way EPA uses in the non-attainment context when it looks for the contribution of upwind jurisdictions to downwind non-attainment problems. Even when there's interstate effects, what does it use? Well, it uses wind roses. It uses emissions, geography, jurisdictional analysis, and weather patterns. It doesn't even use back trajectories, and it certainly doesn't use modeling in the ozone non-attainment context. It only uses back trajectories for the hardest cases. And that's precisely all the work Louisiana did here. So it's certainly a sufficient and reasonable way to get at it. And the only question that EPA should have asked is this a reasonable way to get at it? Is this a good way to get at the question of whether or not there's a significant contribution? It didn't do that. And so that's why the standard of review is so important, because it wasn't asking the right question. There's no reason to put Louisiana's work in opposition to the modeling and say that it has to undermine the modeling unless you buy into EPA's approach that says the modeling is effectively dispositive. So it's only if they apply their preferred approach under the four-step framework that they shouldn't get deference to, that you then get to the question of whether or not Louisiana's work somehow undermined it. Now, I do want to say, even if you do that, Louisiana's work is certainly sufficient. And there's three problems that EPA did when they tried to say that it did not undermine it. One, they acted inconsistently with their own statements. So in the final rule, in the proposed rule, they said that back trajectories can, of course, undermine modeling. They said that the modeling can be tested, its plausibility tested by back trajectories. It even ran its own back trajectories because they were relevant. It didn't use them for anything, but it ran them because it said it was relevant, that they can assess the quantitative and semi-quantitative and qualitative contribution, that they're a way to get to it. And it, again, has done the very same thing in the downwind attainment context. So one, it was inconsistent. All these are general administrative law points. None of them require technical analysis. It was inconsistent. Two, it ignored Louisiana's central point, which is that on high ozone days, it sends downwind from sources of emissions that might be a significant contribution only 10% of the time. EPA never addressed that 10% figure. It didn't even mention it. It never disputed it, that if there really was it was only coming from areas that with significant emissions 10% of the time on high ozone days, that would somehow still be a significant contribution. It didn't dispute that the southern area of Louisiana is the only area that could send those significant contributions. Instead, it focused on an irrelevant point, which was the general percentage that Louisiana is upwind on high ozone days, which, again, Louisiana said is not the relevant point. It's not the point that's tied to the statute, because what matters under the statute is emissions and sources of emissions, which is what Louisiana focused on. And three, EPA reached its conclusion without evidence. So it rested in the final rule on the notion that there were technical flaws. It never put forward any evidence that there were technical flaws. The only thing it said was that Louisiana did not consider areas to the side of the back trajectories that they could potentially contribute. There's no evidence that they didn't do in the record. I think the evidence is counter to that, because Louisiana looked at giant portions of the state, north versus south, which is not a narrow line. But even if it did, even if there was some problem, EPA didn't show that it made any difference. They did their own back trajectories. They did their own analysis, just like Louisiana did. They didn't say that it undermined Louisiana's conclusion. They didn't say they would have come to a different count or that it made any difference in the world. So for all those reasons, EPA's SIP disapproval should be vacated. I see that my time has expired.
May it please the court, I'm Maureen Harbourt and I represent the Louisiana industry petitioners. Louisiana sources do not significantly contribute to non-attainment with the 2015 ozone NAAQS in any other state, and nor do they interfere with maintenance of such NAAQS. Louisiana's Good Neighbor SIP submittal met all requirements of the Clean Air Act and was supported by objective evidence. EPA's disapproval of that SIP was arbitrary and capricious in that EPA relied almost exclusively on its four-step methodology, projected modeled impacts, and then it ignored key elements of Louisiana's submittal. All areas of Louisiana are in attainment with the ozone standard, and those values have steadily declined over a decade. EPA's assertion that Louisiana sources significantly contribute to ozone non-attainment in Texas is based purely on its modeled projections. Louisiana started with the EPA's recommended 2017 modeling predictions as a screening step to evaluate contribution. Those projected low impacts in 2 Dallas-Fort Worth monitors and 3 Houston monitors. But then Louisiana provided EPA with information and analysis that contradicted those modeling predictions. Louisiana emissions of ozone precursors, NOx and VOC, were steadily declining, not substantially rising as EPA projected in the model. EPA's projections showed that Louisiana precursor emissions in 2023 would be as high as they were in 2014. That was contrary to the evidence. The Louisiana SIP submittals showed that reductions of ozone precursors since 2005, including every single year between 2011 and 2017. Then Louisiana indicated in its SIP that there were additional on-the-books control regulations that would be further reducing ozone precursors over the next 10 years. Louisiana then, when EPA proposed to disapprove of the Louisiana SIP, Louisiana commented back, we've had additional reductions from 2017 to 2020. Why are you saying we're projected to have a lot more in 2023 when we're showing that we have actually less? Louisiana's data also in the SIP submittal showed that ozone design values declined through the same period, confirming the impact that those precursor reductions were causing. And EPA's own data in the record show that the design values from 2010 to 2020 decreased at all Louisiana monitors. So what did EPA say in response to this objective actual information? That reduction trends in precursors and design values are irrelevant because they're not tied to a specific numerical decrease in the modeled ozone value. In response to DEQ's question as to why it was projecting increases for 2023, EPA gave only a cursory response that Louisiana precursor emissions fluctuate. They do not. They have steadily decreased. More importantly, they never went above they were much lower in actuality than any of the levels that were projected for 2023. And EPA's proposed disapproval did not even mention as a reason for not approving the SIP that Louisiana precursor emissions or design values had decreased. In addition to the back trajectory analysis that my colleague from the state already said, those actual emissions, because they were lower, and the back trajectories during actual years showing that only portions of the state were covered, necessarily mean that the levels that Louisiana was contributing were much lower than what EPA projected in the model. But EPA never undertook any critical review of either the reductions in emission precursors or the back trajectory analysis. I see my time is up. Thank you. Any questions? Thank you.
May it please the court, Sarah Izfar for the United States. As with the Texas argument, I'll be splitting my time with my co-counsel, Ms. Lee. I'll be speaking about EPA's general SIP review authority here, and Ms. Lee will address all the specific arguments about Louisiana's technical flaws in its plan. So please save all of your back trajectory questions for Ms. Lee. But I just want to focus first on the kind of deference issues that have come up. Louisiana adopts a particularly unworkable standard in its reply brief and in its argument, arguing that deference is appropriate to EPA when EPA approves a SIP and exercises its discretion to overlook a state's technical shortcomings. However, deference does not apply when EPA disapproves a SIP and does not overlook shortcomings. That can't possibly be the appropriate legal standard. Certainly, EPA's SIP review authority does not depend upon the outcome of its determination and its review.
With respect to the scope of whatever part of the argument you're handling, help us this go around by giving us the case authority that you're most relying on. We've got sort of the ton of briefs on both sides. Some of it's like ships passing in the night in terms of ozone and so forth. They have, they're relying on Luminant, they're relying on several of our cases. So help us on your side to pinpoint the case authority that'll help us get to where your argument is. You follow me?
Right. So I would direct your honors to BCCA versus EPA, which all petitioners cite with approval. It's a 2003 Fifth Circuit case, and none of them really grapple with the facts because there EPA was looking at a SIP and reviewing it and had to answer the question of whether the SIP contained necessary and appropriate enforceable limitations. And EPA came up with this three-step framework to analyze whether that was true. And the court upheld that framework. So EPA first looked at whether the enforceable commitments were limited, and then it looked at whether the state was capable of fulfilling it. None of those steps were actually in the statute, but EPA has the authority under its SIP review authority to come up with guidance and framework to give content and meaning to the statute. And that is exactly what the 4-step framework is. And I'll just note that it has not been applied just in the context of a FIP in EME Homer. It has also been applied in the SIP context as well. And EPA has been defining significance and defining the terms of the statute as far back as 1998. So in 1998, EPA issued the NOx SIP call, where it basically made a finding that all of the SIPs were inadequate. So this is in the context of a SIP review. It made a finding that all the SIPs were inadequate, and it set emissions budgets. It said, states, you need to reduce your emissions by X amount. And the court largely upheld that approach in the DC Circuit and Michigan v. EPA. And then EPA then again set another rule where it basically established good neighbor obligations in 2005, I want to say, but it was largely upheld in the North Carolina v. EPA case that's cited in our briefs. And in that case, EPA set obligations. It says, if you want to do a SIP, that's fine. Otherwise, we can do a FIP, but these are your obligations, and you need to reduce your emissions by X amount. And that approach was also largely upheld by the DC Circuit. And then in EME Homer, the states argued the opposite. They said that EPA actually has to define significance and good neighbor obligations before they comply. And the court in EME Homer said, no, states don't have to do that. EPA doesn't have to do that. There's nothing in the statute that requires EPA to define good neighbor obligations. But EME Homer never said that EPA lacked the delegated authority to define good neighbor obligations. This is a federal statute, and EPA is tasked with interpreting it as the federal agency tasked with implementing the Clean Air Act. EPA has to determine whether the plans meet applicable requirements. And that's why it applies the 4-step framework. But I want to note that, as my colleague will stress, EPA thoroughly examined all of the alternative frameworks. EPA didn't say that any states had to follow the 4-step framework, but the 4-step framework has been upheld as reasonable. It's been used for decades. If you look at all the memos that they're citing as guidance, every single memo describes the 4-step framework in detail and says states can use this method, or they can use an alternative method that satisfies the requirements of the Act. And all of the flexibilities are in the context of the 4-step framework. So yes, the 4-step framework is guidance, but EPA absolutely has the statutory authority to determine to develop that kind of guidance to determine good neighbor obligations.
Well, their argument is any discretion falls on the side of the state and not the EPA, that in the cooperative federalism model, et cetera, they say even all that, but once you review our plans, the deference, if you will, or whether something's significant or insignificant, that the deference goes to Louisiana. In this case, if I'm understanding the argument right, they're saying the deference should go to them based on that quantification. Right.
So a couple points here. The court has to always remember the EPA standard of review applies here. So the court is reviewing EPA's disapproval for reasonableness. And under the EPA, it's a deferential standard that applies not just to EPA's technical deference, but EPA's policy judgments where it's explaining how the statute should be implemented. But also the deference issues are kind of collateral because EPA isn't saying that the 4-step framework is the only way to do things. EPA is saying states haven't proffered any sort of reasonable interpretation. And so we're not dealing with a situation where we have two reasonable interpretations and the scale tips in favor of the states. That's not this case. But if it were, they're factually wrong on the theory of deference, because if you look at all the cases they cite, starting with Union Electric, starting with Train, all of those cases recognize that states have wide discretion when setting control standards. They drive the regulatory process. Here, their plans did not propose any additional regulatory controls. They said that our current controls are fine because we're not significantly contributing. EPA, as a legal matter, defines the applicable requirements and defines whether the applicable requirements are met. So EPA has to satisfy EPA standard, this EPA standard of review and engage in reasoned decision-making. It has to conduct an independent review. And this is something EPA does with all of the state plans. Like it does its own independent review, looks at the best available data at the time that's available, and determines whether they are substantively correct. And here, their technical justifications for the plan were not satisfactory to satisfy the good neighbor obligations. And EPA was very clear, both in the proposal and in the disapproval, what exactly was required. And this is not some sort of significance determination, because all of the states largely applied the four-step framework. All of them used the four-step framework, but then made slight tweaks or deviations to kind of use off-ramps to excuse themselves from conducting further analysis at step 3. But EPA made very clear that if states are linked, the expectation is that they need to look at their actual controls. None of the states actually did this, not Louisiana, Texas, or Mississippi. They didn't look at their actual controls, actual emissions, consider potential emissions control opportunities, look at what the other states are contributing. None of the collective contribution problem that we explained up front was addressed by the states. They looked at their emissions in a vacuum. And one other point I'd like to make about the procedural deadlines, there's been a lot of talk here about how EPA delayed and how EPA loses its ability to substantively review. There is no case law to support that when EPA misses a SIP deadline, it loses its substantive ability to review and its independent ability to review. To the contrary, as we explained, the one remedy in the Clean Air Act is Section 304A. It is to bring a deadline suit, which is what the amici did here. And none of the petitioners brought a deadline suit. None of them were interested in ensuring that EPA acted in a timely fashion. And so...
Well, they don't bring the deadline argument. They say by delaying it, once you reviewed it, not you, once the agency reviewed it under criteria or matters which wouldn't have been on the table had the review been done at an earlier period. I don't hear them making a deadline argument to which they didn't file a deadline suit. They're saying once you did it later, you can't reevaluate it. Counsel's test example he gives of grading the paper based on something that occurred after. Maybe I'm misunderstanding the argument, at least that's the way that I'm perceiving it.
Yeah, well, we disagree with the test analogy just because the test...
Well, I'm not asking you to go there. I'm just saying you're arguing about the deadline suit. They don't say we could have, should have filed a deadline suit. They're saying if EPA does it late, it can't alter, change, broaden the criteria by which their SIP is evaluated. And if you do that whatever difference you're given under APA, you overstep that, and any discretion then opts to the state. Now that's a oversimplified notion, but that's the way I understand what they're
Yeah, no, I absolutely understand their argument. My point was simply that there's nothing in the case law, nothing in the Clean Air Act, and nothing in EPA's understanding of its SIP review authority to support that position. The only remedy when EPA misses a deadline, it doesn't get penalized for... It doesn't get prohibited from doing its job of ensuring that the SIP meets all applicable requirements.
We've got a review here under the EPA. And so you can't be arbitrary and unreasonable.
Right.
And why, I don't see how the EPA could say, well, we don't care what your plan said. Your plan looks at this time period and we didn't get around it till 2 or 3 years later. So we're applying a whole different set of data to decide whether your plan works or not. Now, how is that not arbitrary?
So 2 points, Your Honor. The record doesn't reflect that. As Ms. Lee will explain, EPA had closely looked at every single one of the submissions on its own face and determined they were disapprovable on their own terms. The updated data confirms that these states are still contributing. Louisiana is contributing 3 to 4 ppb to these receptors in Harris County and Galveston County, and that is way above the screening threshold. And they still concluded our contributions are insignificant. So the updated data, which is what EPA, I think, under APA review, has to look at, because otherwise, if it ignores relevant data at the time it's making its decision, it could subject itself to liability under the APA. And we cite 2 Sierra Club cases, one in the 3rd Circuit and one in the 9th Circuit, where EPA's action was actually vacated because they ignored relevant data. So I don't think it's true that EPA has moved the goalposts. The goalposts have always been attainment of the NAAQS. And the modeling and the data and the measurements and everything, it's all about trying to, as accurately as possible, assess what are the contributions going to be like in 2023. And so EPA looks at all of that data. It looked at what Texas submitted and what Louisiana submitted and what Mississippi submitted, but it also had its own data. And under every iteration of data, the states were contributing and they took no additional analysis that was required and expected as clearly explained in the proposal and in the disapproval. I see that I'm out of time, so unless the court has any further questions, Ms. Lee will cover the rest. Thank you.
What's the point of having the states go through this SIP process if the EPA is not going to look at it till 2 or 3 years later and then decide based on its own what it wants to do based on current data? I mean, it seems like there's a total mismatch here.
Well, Your Honor, as my colleague Ms. Izfar explained, what the updated modeling does is merely just confirm that the modeling and the data that the states used here, I guess we're talking about Louisiana, simply confirmed EPA's conclusion that the data consistently shows that these states contribute to downwind ozone pollution problems and therefore under the good neighbor provision are expected to further evaluate their contributions by looking at their sources and determine what their emissions contribute significantly or interfere with maintenance, and then eliminate only those emissions that will significantly contribute or interfere with maintenance. And so, as the record reflects, all throughout the proposal and in the response to comments section, EPA has made clear that it reviewed each state's submissions and their comments thoroughly and found that those submissions failed to comply with the good neighbor provision. And so I'll speak about Louisiana since we're in the Louisiana segment. But what Louisiana did, and I'll just step back because as you have noted, Judge Stewart, it does seem like we're ships passing in the night. What Louisiana and EPA both did was look at results from photochemical grid modeling, which I previously explained is the best state-of-the-science tool for estimating ozone concentrations and contributions in the future, which is what is asked of us under the good neighbor provision. What the photochemical grid modeling showed under Louisiana's chosen model, and then the model that EPA considered, was that Louisiana contributes way over its chosen 1 ppb contribution threshold, which it set as a screening threshold to determine if it is among the upwind states that contribute to downwind ozone pollution problems, such that it should proceed to consider its contributions further by looking at sources and emissions and determine what emissions of theirs contribute significantly to non-attainment or interfere with maintenance. However, this is where Louisiana, like Texas, defines significance in a different manner. Louisiana defines significance, like Texas, as a persistent and consistent pattern of contribution on high ozone days. And the record shows that, like Texas, Louisiana's definition of significance fails for the same 3 reasons. First, like Texas, Louisiana did not explain when this pattern is established. For example, and I'll point your honors to the record, the Louisiana proposal at 9814. Specifically, EPA had commented to EPA commented to Louisiana, that it should define what this definition meant. And Louisiana did not define it. Rather, Louisiana defined the pattern. Louisiana stated that it had defined the pattern and has provided back trajectories on those monitored exceedances, which will show that the definition is applicable to the conclusion. It provided a circular reasoning and did not explain when that pattern is actually established, nor why that pattern is relevant for evaluating good neighbor obligations when, as I previously explained, whether a downwind state has ozone pollution problems and whether there are good neighbor obligations to be assessed is not at all dependent on this pattern at all. But second, like Texas, EPA reasonably explained, again in the record, the same page, that Louisiana's own analysis showed that it contributed to downwind ozone pollution problems on sufficient number of high ozone days, because Louisiana, like Texas, also calculates contributions by averaging its contributions over 5 to 10 high ozone days, which is more than the necessary amount of high ozone days for a downwind state to have ozone pollution problems. And so even under Louisiana's chosen definition of significance, Louisiana should have proceeded to further evaluate its contributions, yet it failed to do so. But third, contrary to Louisiana's arguments otherwise, EPA did fully evaluate the analysis that Louisiana put forward to argue that its contributions were insignificant, and EPA reasonably determined that the analysis that they put forward did not actually support their conclusion. I'll just address the two that were mentioned by Petitioner's Counsel, which are back trajectories and Louisiana's own emissions. As for back trajectories, EPA reasonably explained that photochemical grid modeling, which I just explained, is the best tool for estimating ozone concentrations contributions, already takes into account the one factor that back trajectories assess, which is wind direction. Not only that, but it accounts for numerous factors, including all of Louisiana's own emissions. And Louisiana's chosen photochemical grid modeling has shown that Louisiana does contribute above its chosen contribution screening threshold to multiple downwind receptors in Texas, and therefore should have proceeded to consider its contributions further. Not only that, but even if we do look at Louisiana's back trajectories, Louisiana's conclusion wrongly assumes that that one line provided in a back trajectory is the only path that air can take. And just to step back, what a back trajectory shows is simply an estimation of the most likely path that air can travel, and it does so by showing one single thin line. But as we all know, air disperses, and so the further you get from that downwind receptor from which Louisiana starts its back trajectories, the further you get back in time, the greater the geographic scope from which air could have traveled. So what EPA is explaining in the record and in our brief is that as you follow that line, the geographic scope from which air could have traveled greatly increases. And so if you account for either side of the back trajectory line that Louisiana provided in its submission, then it's clear that Louisiana's own back trajectories supports the conclusion that air often travels from Louisiana to those downwind receptors in Houston and the DFW area. Third, EPA also conducted back trajectories. EPA expanded upon Louisiana's back trajectories by running back trajectories over a 12-year period as compared to Louisiana's 3. And by running more and more back trajectories, it further and further confirmed that air does travel from Louisiana to Texas, and confirmed the photochemical grid modeling results that Louisiana contributes to downwind ozone pollution problems in the Houston and Dallas areas, and that it should have further evaluated its contributions by looking at its sources and their emissions, and it failed to do so. And then I'll just address next the Louisiana's emissions. As an initial matter, EPA reasonably explained that an in-state emissions is not relevant for evaluating good neighbor obligations, because the good neighbor provision asks whether a state contributes ozone pollution problems downwind. So it's very possible that Louisiana does have clean air if their emissions don't stay in state but travel out of state and contribute to ozone pollution problems in Texas, in Houston and Dallas. And so having clean air doesn't excuse a state from assessing its good neighbor obligations, particularly where the photochemical grid modeling results show that it does contribute to ozone pollution problems. And then regarding the arguments about how Louisiana had commented, saying that its modeling projections of Louisiana's ozone precursor emissions and ozone concentrations were wrong. EPA fully accounted for Louisiana's comments And that's what the updated modeling simply is. The updated modeling considered at the final rule in the disapproval was simply incorporating the comments that people raised regarding the modeling. So it further refined the modeling, and it fully accounted for the comments that Louisiana made. And so what that argument actually highlights is that the updated modeling is very relevant for evaluating good neighbor obligations, and EPA lawfully and reasonably considered it, as my colleague Ms. Izfar explained. But along with that, though, I just note that that argument, to the extent that it is considered, we note that that was not raised in petitioner's opening briefs, and respectfully ask this court to consider it waived. And so, in sum, none of Louisiana's analysis supported Louisiana's conclusions that its contributions to Texas were insignificant. So even under Louisiana's flawed interpretation of EPA SIP review authority, even if this court were to just consider Louisiana's submission on its own merits, EPA reasonably explained throughout the record why Louisiana's analyses failed to support its conclusion and lawfully disapproved it. Thank you.
So I want to follow up on a couple of things that EPA said on the general deference, BCCA 2003. Yes, it does matter whether or not EPA is approving or disapproving a SIP, because if it's disapproving a SIP, it can't use a rulemaking to impose a rule that didn't exist at the time the SIP was submitted. On the other hand, if it's approving a SIP, it can use its rulemaking power to create a prospective rule, and what the SIP is doing is also creating a prospective rule, so they work together to create a rule for the future. EPA mentions the NOx
Counsel,
SIP law.
when has that ever been done, what you just said?
So that, when is what ever been done?
What you just said, they can
The
go
BCCA
back and work
2003.
together. Okay.
I'm sorry, that's when a prospective, they have not created a rule retrospectively to judge it. In the NOx SIP call, they created a prospective rule that set the SIP obligations, and they could have done that here if they wanted an authoritative binding standard. But they didn't, and now they're trying to justify what they're doing after the fact, even though it's applying it retrospectively.
Okay, Louisiana says, notwithstanding these other arguments, they evaluated Louisiana's data under Louisiana's three-step process, which is roughly analogous to 4 states, and the deference, et cetera, without me understanding back whatever trajectory. Bottom line says that even under your, not you, but Louisiana's own criteria, not future projected model, but under what Louisiana submitted, that what was insignificant or not was not properly attended to vis-a-vis its effect on other areas. So without waiving, conceding, all the other stuff about 4-factor, and the rest of it, but down at this end, they say they looked at Louisiana's data submitted, et cetera, and that Louisiana did not account for the effects otherwise. So just cut to that part.
Yeah, yes, Your Honor. So 2 things. One, they applied the wrong standard of review, so that doesn't matter because they were looking at it through the wrong lens. And if they had looked at it through the right lens, they wouldn't even ask the same questions. They would have asked, is this reasonable? Yes, it is. And they wouldn't have put it in opposition to their own work. But 2, no, I went through previously in my previous statement about what EPA said. I didn't actually hear them address anything I said, so there's certainly no need to undermine it in terms of modeling versus back trajectories. 3 years of actual wind data can certainly undermine 1 year of modeled wind data, and EPA recognizes that. They repeated the idea that there was, Louisiana didn't consider areas to the side. Again, there's no evidence in the record of that. Louisiana considered giant areas of the state.
Help me with that.
Yes, Your Honor.
I guess we're going to be forced to take a month to read every tittle that's in this record in order to figure it out, because you're both citing stuff purportedly in the record which supports X or which supports Y. We get the arguments, but it's just going to come down to us making a granular review, so to speak, on whatever. I understood, and I could have misheard, the argument to be was that in the record, EPA said to Louisiana, 1, 2, 3, 4, based on the data. Is it in the record or not? In other words, I understood her response back to say, we reviewed Louisiana's plan, we reviewed the emissions, et cetera. We specifically told Louisiana where these deviations are, et cetera, et cetera. That's what I'm saying, whereas you're saying, okay, in the record, it's nowhere in there where we were told, et cetera. That's where I'm in the fog. You see what I'm saying? I'm saying it's either in the record or not, in terms of what was said, what's not said. The state seems to say they came out with some global from Washington, view here. I know the light's red, but, it's the nature of the case. I'm just trying to get past. We've read all the briefs. We're going to read it all, et cetera, but to sort of make sure that we're getting the arguments that's meeting each other rather than just projections, et cetera. They say we iterated specifically where Louisiana did not meet its own modeling, its own data, and so no deference is owed to Louisiana's failure to adhere to its own data and material. That's at least the way I understood it. Okay, so help me understand, is there something in the record or not where EPA specifically does iterate 1, 2, 3, 4, here's where you failed or not, or are we back to the deference of it? That's all.
Yes, Your Honor. So I'll clarify a little bit about what happened and then point to exactly that. So EPA had some initial comments on Louisiana's draft SIP. Those initial comments are not binding in any way, and so they're not authoritative, and EPA certainly didn't promise that it would approve it if it did what it said. But it had comments on its back trajectory, so Louisiana went back, reran ones that it actually did later on. That's what it provided, and it did so, and it went from just certain days of the month back trajectories to examining all of the days where there were ozone exceedances at the downwind receptors in Texas. So it created more relevant back trajectories. It used those in its final SIP. And EPA commented on the fact that it would like a clearer definition. And the point of Louisiana's response is just that it was going to provide all of the evidence for why it reached the conclusion it did under its weight of evidence approach. And so if EPA has a difference of opinion, that's not good enough. Under a weight of evidence approach, you give the data, and that's what you have, right? You're saying, as a weight of evidence, I'm weighing all the factors, I'm coming to this conclusion. That's the approach Louisiana took. That's the approach EPA takes in a lot of cases. And even in that BCCA 2003 case, used a weight of evidence approach. So that's what Louisiana was saying there. On its finals, after it submitted its final SIP, EPA said, well, look, these back trajectories, you're not considering the center line. As far as I understand, they didn't mention that beforehand. But the point is that there's no evidence in the record to show that Louisiana failed to consider the notion that you have to consider areas to the side of the center line, again, because it looked at just back trajectories going through the north of Louisiana or the south, and it said the major sources of emission are in the south. That's a huge area, right? So it's picking up only the major source of emission. Southern Louisiana is a huge area, so it's not considering very narrow points. As Counsel for EPA said, EPA then ran its own back trajectories. Well, it didn't use them to address anything relevant, right? It didn't say, okay, we ran these, we're coming to a different count on the same days you looked at it because, we're considering that, well, this is really close to source of emission, so we need to count it. They didn't redo a count. They didn't come to a different conclusion than Louisiana did on any of their back trajectories. What they're saying is that, well, it confirms our modeling, which again is irrelevant because you don't put the modeling in opposition to what Louisiana did unless you accept their approach. But it said that confirms our modeling just because there's some error that comes downwind from Louisiana on high ozone days, which again is not relevant because under the Clean Air Act, under the Good Neighbor provision, what matters is it coming from sources of emissions. And so Louisiana looked at that, EPA didn't. EPA didn't address Louisiana's arguments, so you don't need to get into technical analysis, you just need to say under ordinary administrative law principles, did EPA do what it was supposed to? And it certainly didn't. And that's an independent reason to vacate the SIP, but certainly if it didn't apply the right standard of review, then you don't need to get there because it definitely could have changed the outcome. EPA should have done an entirely different approach to looking at Louisiana's work.
Okay, thank you.
Thank you.
Well, I'm not sure I understand. I thought
Sure.
they said that your own modeling showed that emissions were coming from Louisiana to Houston and DFW.
It does, Your Honor, but that's not the end of the story. What the question is it a significant contribution? And Louisiana said it is very infrequent that that happens. And it looked at other things like wind roses, which confirms that it's infrequent that that happens. And it said only about 10% of the time, which is approximately 10 days over 3 years across 2 receptors, that it was coming downwind on high ozone days from areas that might contribute. They said that's insufficient. And under a reasonable interpretation of significant contribution, I think that's reasonable. And if EPA wanted to set a different rationale for what a significant contribution was, it could have done that ahead of time with the rule, but that's certainly a reasonable way to approach it. And so if you apply the proper standard of deference, Louisiana's work should be approved. But even if you don't, again, they didn't engage with the central analysis that Louisiana did.
Okay, thank you.
I have 1 minute, so I'll be brief. EPA did not use the best available data at the time of disapproval of Louisiana's SIP. It looked at updated modeling data. It never addressed Louisiana's actual data showing actual ozone precursor declines through 2020 at much lower levels than it used in the model inputs.
But she just said they did.
Pardon?
Her argument up there was that she did look at the actual Louisiana data.
They did not look at the actual Louisiana data. If you'll listen carefully to go back and listen, she said that they updated the models, okay? And that was the 2016 V2 to 2016 V3. They never gave Louisiana a chance to even comment on the inputs to those 2 models. Our screening model was the one before that they put out with the guidance in 2017. And our levels of actual emissions that Louisiana kept telling them are in the SIP itself, and then in its comments in the SIP, our actual levels are going down, and they're going to go down further because of these rules that we've indicated in the SIP. And you're projecting that they're going up. We don't understand why you're projecting they're going up. And that's what they never looked at was the actual data. They looked at the modeling data, not the actual data. Thank you.
Okay, before Louisiana sits down for good here, on the issue of whether it was proper for EPA to rely on post-submission data, okay, you following me? What costs or other harm did Louisiana incur due to reliance on the 1 PPP memo?
The post-submission.
Yes. Post-submission data. What's the harm or other costs did Louisiana incur based on reliance?
Based upon reliance. Well, first of all, Louisiana never got the opportunity to comment on any of the data that went into the 2016 V2 or V3 modeling. That they started with a screening model that EPA proposed and recommended that we use that was based on 2017 in the 2017 memo. And we used that data, and they never said anything was wrong with that. It was EPA's own modeling. We used it as a screening tool. Never said why we're years later switching to a different model platform, different model inputs. We never got the ability to comment on those. So the detriment is we don't know if what the information went into 2016 V2 was correct or not. We didn't get the opportunity to address that in any way. And it wasn't relevant to our analysis, which was the state has the primary duty first and foremost to do the analysis of whether there's significant contribution. We did that using an EPA tool.
Okay, so in response to my question, as far as cost or other harm Louisiana incurred, it's basically a loss of opportunity to respond?
Yes, and as a result of that, that EPA imposed its own federal implementation plan, that there will, of course, be costs to the people that will have to comply with that plan. That's the separate lawsuit. But yes, I mean, the answer is the state did not get to address those issues, determine if they were correct or not correct, didn't get to, basically is that they didn't get to say why, but they never got the opportunity to get their state implementation plan a fair review.
Thank you.
Thank you.
Mr. Stewart?
Thank you, Your Honor. May it please the court, I'm Scott Stewart on behalf of the Mississippi petitioners. Just me today for Mississippi and the associated Mississippi petitioners, Your Honor. I'd like to get straight to why Mississippi's SIP satisfies the good neighbor provision and why it should have been approved. I think in doing that, going into the story of what that SIP presented EPA with, what it told, and why the state reached the conclusions it did, I think it really presents Mississippi as an acid test for whether the EPA was serious here in heeding its secondary proper role in the good neighbor provision in the SIP context in this case. I think it shows that, unfortunately, the EPA did not pass that test and did exceed its authority. And basically, if I can, I'll just sort of run through the key points on Mississippi's SIP and how it reasoned to the fact that it had no significant contribution to downwind air quality problems. After EPA issued the 2015 ozone NAAQS, Mississippi looked at the Clean Air Act, it looked at the good neighbor provision, it looked at EPA guidance, it looked at the data, the modeling that it had, and it basically saw three central points. The first is Mississippi's numbers were really, really good. You look at the March 2018 memo, it lays out, look, these are the 26 downwind attainment or maintenance sites with air quality problems. At the overwhelming majority of those, Mississippi is at or very close to zero in contribution, projected contribution. It's under 1 part per billion for all of them, and its highest contribution is 0.79 parts per billion to a single site. So just starting out, Mississippi's numbers were very good. They're just quite good. Not every state across the country, of course, can say something as strongly as that. So that was sort of the first step. Very good numbers. Next, Mississippi looked to EPA's guidance and what should we do with these numbers? How should we evaluate what to do next? And basically, the August 2018 memo, sometimes referred to as the 1 part per billion memo, said, look, the EPA has itself used a screening threshold to determine what a contribution is or isn't over time. The Clean Air Act, the Good Neighbor provision, doesn't dictate a number. It doesn't dictate a particular percentage. The EPA has used 1% of NAAQS, but hey, other thresholds for screening could be used as well, could be reasonable and appropriate. And hey, 1 part per billion and 1% of NAAQS, which here 0.70 part per billion, they're very close. So, this is a matter of judgment, and 1 part per billion is very close. So Mississippi looked and said, well, look, we're under 1 part per billion everywhere. I mean, we're under 1% everywhere but one place, and there we're only 9/100ths of a part per billion. So, that sounds pretty persuasive to us. So EPA is looking very good, and that gets to the third, I think, leg of the stool. And EPA, like I said, they looked at not just the good neighbor provision, but what's the broader look of the statutory structure here? Similar terms, and how do you look at them? So EPA looked at the analogous guidance for a very similar program, the Prevention of Significant Deterioration program, and the key point there is that program is involving the same air quality standard, the ozone NAAQS, the same pollutant, ozone, the same sources, and the same goal of saying, hey, what's a threshold to determine contribution? And it's very important that in the context of that program, the EPA has itself determined that you don't contribute, to use the statutory term contribute, you don't contribute unless you hit 1 part per billion. So Mississippi said, well, look, what we're trying to evaluate here is, do we contribute significantly? If you don't contribute until you hit 1 part per billion, surely you don't contribute significantly if your highest is 0.79 parts per billion. So that's where we are, and that was Mississippi's pitch. It was its presentation. It, of course, used the technical analysis and modeling that the EPA itself had put out for the purpose of helping states to satisfy their good neighbor obligations. And that's what Mississippi presented. That was reasonable. It rested on reasonable judgments. It was reasonably explained. That should have been the end of the story. EPA erred, it exceeded its role in disapproving that. And really, I mean, that's enough for this court to vacate the disapproval of Mississippi's SIP. I can emphasize, the court has, of course, heard much, I think, about the later modeling. I wanted to be sure to get out that, hey, look, even if that modeling had ever happened, we are very, very good on our numbers. We presented a very compelling SIP. It satisfied the clean air obligations. But I will say, it's striking to me that with this later modeling, the EPA's position is really quite breathtaking. There's no, I think, limiting principle. There's no stopping point to EPA's pitch that, hey, it can consider whatever the latest modeling is. And oh, by the way, EPA is continuously updating its modeling. And I think that's, one, very problematic from just a notice, arbitrary and capricious standpoint, but also it's just not consistent with the deadline structure and also just the way that the EPA and the good neighbor provision, all of this kind of updates over time. It's not static. You have new NACs come out every so often, and Congress recognized, look, the state is going to have to operate with certain data in its window. EPA is going to have a much shorter, truncated window to review that. It is appropriate for EPA to evaluate the data that was available at the time of SIP submission.
Mr. Stewart,
Yes, Your
so
Honor.
is Mississippi, in the context of these three states, in a unique position, more of a unique position, I guess, that the post-submission data affected your ability to comply, period?
I think that's right, Your Honor. Certainly it was leveraged. I think it's fair to say, oh, you are above 1 part per billion, at these places now, so it's inconsequential that you were, you made this pitch on the 1 part per billion. So I think it did hurt us there. I don't want to disclaim that anyone else has, fair issues with the later modeling, but surely I think it worked to our detriment. And oddly, it didn't work to our benefit at all, because the one place where we were projected to contribute above 1%, we were no longer linked to there, and that did not inure to our benefit whatsoever. So we kind of had the door hitting us both on the way in and on the way out, so to speak.
And is your position then, where EPA is saying that you failed to analyze reduction opportunities, or to that effect, that it's obvious that you were under 1 parts per billion, the closest you got, to use your words just a second ago, 0.79, and so that was the reason you didn't? Or I don't want to put words into Mississippi.
I think that's just about right, Your Honor. I think what we would say is, look, you only have to take these actions if you significantly contribute. If you have no significant contribution, then you don't have to do more. You're fine, and you're not causing a problem. And our pitch is that we're not significantly contributing.
Okay.
And so we don't really get there. I think I think it does kind of draw out an important theme here where the EPA has referred to this 4-step framework during this argument, I believe, as a, quote, an organizational tool. It'd be one thing if this were just kind of a reference point, a way to structure analysis, and EPA were really seriously not imposing this or 1% threshold on states. But I think in practice it is shaken out very, very differently. And I think part of the problem here is that we were above just barely 1 part percent at one place, and the EPA improperly overreached and disapproved us based on that, even in the face of a very good technical presentation. The EPA, I think it's important to emphasize that, it didn't show or kind of say, hey, you're unreasonable. It say, hey, you lacked a sufficient technical justification. But you have to look at the nature of what our contribution was. It's not like we had sort of 20 downwind sites where we were contributing, say, just barely, say, 0.99 parts per billion, where you might say, well, okay, maybe they should get in a little bit more analysis, a little more reasoning, explain why, 20 places, even if they are all under 1 part per billion, why that's still okay. We had only one that was over 1%. So even by the EPA's lights, based on the data available to us at the time we were developing our SIP, we were fine so long as we addressed that one site. But the EPA didn't respect our presentation, didn't give us the proper deference. And I think that drives home just kind of a running theme here is that, the statute itself uses the term primary. The state is primary. This court's cases, I think, repeatedly reaffirm that as compared to the EPA's deferential role, secondary role. I mean, the court has even said, of course, ministerial, but in primary, it has to mean something more than the state gets to go first. The state has to get some measure of deference to its reasonable judgments. I think actually, Judge Stewart, you mentioned EMA Homer a few times, and I think my friend from Louisiana mentioned it earlier. I think one reason that case is instructive is what it teaches, I think, is that whoever is in the driver's seat on making a plan gets to make reasonable judgments. And so that's one thing. So it's one thing maybe perhaps for the federal government to say when it's in the driver's seat, it gets to make certain determinations. Here, of course, we're in the SIP context, so the state does get to make reasonable determinations. I think the second point from EME Homer that's quite important is it recognizes that, hey, the good neighbor provision, it doesn't really dictate. It leaves, in a large way, I mean, significant contribution contributes significantly. That's not defined. It's subject to judgments. And when it's something subject to judgments, you can't treat it like it's a perfect, kind of science where you can get exactitude. It's about, did the state look at the data? Did it look at the modeling? Did it look at the statute? Did it make reasonable determinations with the facts that were before it that are reasonably moored to the statute? And here, I mean, in the case of Mississippi, the answers are very powerfully, yes, the state did make reasonable determinations. And like I come back to what I kind of began with was this really was the acid test for whether the EPA was going to perform its statutorily confined role or whether it was going to exceed its role. And I do think it exceeded that role here. I've mentioned the deadlines. I've mentioned kind of the Mississippi SIP presentation, and I know the court has heard a great deal of argument about a number of surrounding issues. One thing that I think that I'll just kind of emphasize to drive home is you look at Mississippi's numbers and you think, Mississippi's at 0.79. How rough could it be to bring it down farther? And I want to drive home that life under the FIP and as opposed to Mississippi SIP would be extraordinarily damaging to the state. We set this out, of course, at the state stage in some sense, and I think it gets a little bit, Judge Stewart, to what's the proper remedy here? I mean, the proper remedy is vacator of the disapproval. Number one, because we're talking about exceeding statutory authority, and that's not something that we can have really any confidence is something the EPA can shore up with a simple remand. But I think it also just, looking at the massive costs on the state, the harms to the state's people, its economy, we're talking potentially hundreds of millions in compliance costs. We're talking about the harms that, of course, we can expect to be passed on to consumers. We're talking about risk to grid reliability. If you're in the Fifth Circuit, we're talking 3 states that have some pretty rough goes of it in the summer. I mean, the idea of grid reliability problems in a Mississippi summer, I don't want to even begin to, it goes well beyond discomfort and great risks to, just health and safety, given how challenging it can really be. And, on top of all things, so it's not just an intrusion on state authority, but it is a very real, practical, problematic overreach that comes with disrespecting the cooperative federalism enshrined in the Clean Air Act. So I think all those points together drive home the importance of vacating the EPA's disapproval of Mississippi's SIP in full. And with that, I'm happy to save the rest of time for rebuttal, respecting, of course, time, of course, and any questions.
Thank you, Counsel.
Thank you, Your Honor.
May it please the court, Sarah Izfar for the United States.
Could I interrupt you right away? Now we've heard from Texas, Louisiana, and Mississippi, and I still don't quite understand. I'm going to summarize what I think the EPA's argument is on the legality of the 4-step approach. Okay, so all 3 states are saying you exceeded your authority, and that the 4-step framework is improper. You said in your own words that you've used it. When I asked you about authority, you've used it for decades. That's a quote. And that you have statutory authority. And Mississippi Counsel just said that you exceeded your statutory. What I want from you is, where is your statutory authority, and is there any case law and any binding case law that says you have that statutory authority?
So, yes, Your Honor, it's all 7410K3, which is EPA's SIP review authority. EPA has to review SIPs to ensure that they meet all applicable requirements of the Clean Air Act. And so here, EPA is reviewing the Good Neighbor provision, which is 7410A2D1I. And their states shall, there's no confusion here. Every state plan has to contain provisions, adequate provisions that prohibit emissions that either contribute significantly to non-attainment or interfere with maintenance by any other state with respect to national ozone standards. So EPA, in the first instance, has to review these plans for consistency with the Good Neighbor provision. And that is unambiguous authority. So that is our statutory authority. And then when we cite numerous cases, legions of cases in our brief, talking about how EPA has exercised that independent authority, not just in the Good Neighbor context, but in other contexts. EPA regularly conducts its own independent analysis. The 4-step framework is just guidance here. EPA did not say that it was binding, and EPA independently reviewed all of the different SIPs on their own terms. But I will note, every single state adopted some version of the 4-step framework.
So to my question, there is no authority that approves this 4-step framework to date.
Oh, it is up. So EME Homer has upheld the framework as reasonable, and that is in the context of a FIP. But EPA also used that framework in that same case to disapprove 22 SIPs and exercise its error correction authority under 7410K6. So it's not just in the context of a FIP, and EPA has made findings of significant contribution. All petitioners have agreed that EPA has the ability to issue regulations defining good neighbor obligations. So whether EPA uses a framework or whether EPA issues regulations, the task before it is the same, and its authority to review SIPs is the same. It should not matter whether EPA used a framework or issued regulations. They are both acceptable approaches for evaluating obligations under the good neighbor provision. And all of the guidance that was issued, both the 4-step framework, but all of the memos all underscore how the 4-step framework is used. It's characterized as familiar. Many of the states adopted some. So really, like, whether EPA is authorized to use the 4-step framework or not is really a collateral matter, because EPA has upheld, EME Homer has upheld it as reasonable, it's workable and fair, and the states largely adopt it. Really, the question comes down to what the appropriate standard of review is, which is to review EPA's disapproval under the APA standard of review. The states are saying that the Clean Air Act has some sort of written-in obligation that EPA has to defer to the states. There's nothing in the Clean Air Act itself to say that when EPA is exercising its SIP review authority, it defers to the states. And EME Homer has made clear that EPA doesn't have to define its good neighbor obligations ahead of time. So really what we're talking about is whether EPA has to defer to a reasonable state plan. If you agree that they're reasonable, we absolutely disagree that the state plans were reasonable. But if that is the case, there is no case law or statutory support for that in the context of the good neighbor provision. I think
They cite cases to say, yes, starting out the box, EPA has this charge, blah, blah, blah. But, and putting aside the 4 steps, which seems like a whole lot of the argument is over, the 4 steps or not. You say, notwithstanding the 4 steps, it was guidance. They knew it was guidance. You say, we evaluated every state on their own terms. They failed for this reason, this one. So for there. They say, then if you evaluated ours on our own terms and we determined something was, quote, insignificant, you don't get to say it's significant because the deference goes to the state under the SIP analysis because it's the state. They say, baseball say tie goes to the runner here, but they say because it's a SIP and their data in one of the plans, whether significant or insignificant, they say, well, the deference, quote, or they say, our evaluation was, quote, reasonable, close quote. So the fight here seems to be in part over who gets to decide whether the deviation is reasonable or not. Mississippi comes in and says, hey, our numbers were off the charts. We shouldn't even be in this conversation because our numbers are tight here, and based on the numbers alone, we shouldn't be in this discussion. The other states say, well, the numbers are there, but what's, quote, significant, what's, quote, reasonable, and then they come back and they say, well, even when EPA comes down, they never gave us a chance to comment on their later determination. So they seem to argue EPA is evaluating not based on the state's determination, and this is where we hit into, which none of y'all really talked about, the cooperative federalism. They argue Luminant, they argue these other cases. So help us with understanding all these cases we have: Texas 2012, Texas I think 2016, Luminant, et cetera, which have talked about this cooperative federalism, whether EPA's role is ministerial or not. So
This court has recognized that EPA has ministerial SIP review authority if the plan is consistent with the act. So we are before that inquiry because we are in 7410K3 land where EPA is reviewing the plan for consistency with the act. If EPA approves the plan, EPA has very little to say about what kind of control measures they want to use. So whether they want to target factories, whether they want to target cars, whether they want to target, individual homes, that sort of thing. So that is what all of that case law that's talking about, how EPA has to defer to the states. It's talking about it in the context of choosing regulatory controls, driving the regulatory process. They can't cite a single case that says that EPA has to defer to the states when it comes to defining significant contribution and whether they are or are not contributing significantly to non-attainment or interfering with maintenance. And I think it's helpful to take a step back and realize what EPA was confronted with. Every single state who presented a plan concluded we are not contributing significantly to the problem and our provisions are fine. And if EPA had not conducted its independent analysis, then the good neighbor provision would essentially be a dead letter because every single state says that they're not contributing. And no one actually addresses the collective contribution problem that we're talking about, which is that ozone is caused by many small contributors and lots of different upwind states, and they're contributing to the downwind receptors. And so that is why deference is particularly inappropriate in this context, because EPA has to act as a neutral arbiter between the upwind and the downwind state. Well, all of the upwind states, really, because the upwind states, one state shouldn't have to contribute if the other state is in. And so EPA has to act, because of what the good neighbor provision requires, EPA has to act as a neutral arbiter. And it can't simply defer to the states. And I also want to note that they may say that their plans are reasonable. They haven't demonstrated that because they evaluate their emissions in a vacuum. And they can't do that when it comes to the good neighbor provision because of the interstate transport nature of this and because of ozone. With my remaining time, I just want to really briefly talk about this idea that EPA should have issued a SIP call. One, EPA has a statutory obligation under the act to act on the submission before it. It could not issue a SIP call in lieu of that. It was also subject to a court order deadline. But more importantly, I think there's a key concession made here because EPA can only issue a SIP call if it makes a finding that the plan is substantially inadequate. And here, every single state submitted a plan that was almost identical to what they have right now. They said they didn't need to adopt additional provisions. So if they're saying that a SIP call is appropriate, then how could EPA do anything else but disapprove the plan? And how could the court do anything else but uphold the disapproval? Thank you, Your Honors.
May it please the court, Jin Hyung Lee on behalf of the United States Environmental Protection Agency. I will now address why Mississippi's plan did not comply with the statutory requirements of the Good Neighbor provision. But because this is my last time up here, I just wanted to step back and explain big picture fully what this case is about. Under the Clean Air Act, states and EPA have the same goal, which is attainment of the NAAQS as expeditiously as possible. So under the Good Neighbor provision, which seeks to fairly allocate the cost of ozone pollution to those upwind states that are part of the collective contribution problem, which, as my colleague Ms. Izfar explained, means that a downwind state's ozone pollution problem is more often than not the result of small amounts of contributions from numerous upwind states. And so under the Good Neighbor provision, as it relates to ozone pollution, then the goal here is to ensure that those upwind states that are part of the collective contribution problem affecting downwind states' ozone pollution, they're expected to eliminate those emissions that will contribute significantly to non-attainment or interfere with maintenance. And so that's the goal. And under that general picture of what the goal is here for both the states and EPA reasonably disapproved Mississippi's plan because Mississippi's plan did not comply with the statutory requirements of the Good Neighbor provision. Like Louisiana and Texas, Mississippi also used photochemical grid modeling. That modeling, which as I explained, is the best tool for estimating ozone concentrations and contributions, showed that Mississippi does contribute to downwind ozone problems in the Houston area. While Mississippi argues that that contribution is small and therefore is unlike Texas and Mississippi, as I explained, ozone pollution is a collective contribution problem. So even small amounts of contributions matter. And so the photochemical grid modeling showed that Mississippi does contribute to downwind ozone pollution problems in Texas. Mississippi then, instead of further evaluating its contributions to determine what amounts of its emissions will contribute significantly to non-attainment or interfere with maintenance, then sought to then use technically unsupportable arguments to claim that its contributions were insignificant. I'll address the 1 ppb contribution threshold, as that's what Mississippi presented in its brief, or in oral argument. The 1 ppb memo made clear that states were expected to explain, based on the facts and circumstances of their SIP, as to why a 1 ppb contribution threshold would be adequate to effectively capture those upwind states that are part of the collective contribution problem. EPA in prior rulemakings had found 1% of the NAAQS as a reasonable, technically justified screening threshold because that threshold sufficiently captured those upwind states that are part of the collective contribution problem, such that their emissions reductions would meaningfully help address downwind states' ozone pollution problem. So to use a different screening threshold, EPA made clear in the memo that states should put forward why the facts and circumstances were such for their specific SIP that a 1 ppb contribution threshold would also meaningfully address and capture those upwind states that are part of the collective contribution problem. There's a sentence specifically on page 4 of the 1 ppb memo that says that generally, looking nationwide, not at specific receptors to which a state may be linked, that those two contribution thresholds would effectively allow for that next step of the analysis, which is further evaluation of contributions to determine those sources and emissions that will contribute significantly to non-attainment or interfere with maintenance. So the memo wasn't meant to give states an off-ramp to argue that their contributions were insignificant. Rather, it was simply just explaining that there were certain situations where those two both would capture sufficient number of upwind states. And if you look at the specific Deer Park receptor that Mississippi was linked to under its own submission, it's clear that the two contribution thresholds are not generally comparable, because under a 1% threshold, the percentage of upwind states that are captured is over 60%, while under a 1 ppb contribution threshold, the percentage of upwind states that are captured are 36%. It's nearly half. It's nearly reduced by half. And so Mississippi failed to provide the technical justification necessary to explain why a 1 ppb contribution threshold would adequately capture those upwind states. While Mississippi argues that it uses that threshold because it's the same threshold used for a different Clean Air Act program, it doesn't explain why the facts and circumstances here entailed the use of a 1 ppb contribution threshold. And further, I note that the 1 ppb threshold in that other Clean Air Act context is materially different, because what that threshold does is it asks whether a source can be constructed or modified at all. But even if you're above the screening threshold in that other Clean Air Act context, that source is still expected to implement the best available control technologies. While here, the threshold, if you're below it, means that your contributions are insignificant and you don't have to do anything more. Mississippi does not explain why the impacts of the different thresholds means that it could use a 1 ppb contribution threshold here. And just in case, in rebuttal, the argument comes up that it was not explained in the record, I note that it's in the record in the Mississippi proposal on 9557 and in our disapproval in 9372. And so, even under Mississippi's flawed interpretation of EPA SIP review authority, even under just evaluating Mississippi's plan on its own merits, the science is very clear. In terms of trying to attain the NAAQS as expeditiously as possible and meeting the statutory requirements of the good neighbor provision to fairly allocate the cost of pollution, Mississippi's chosen modeling showed that it was part of the collective contribution problem affecting downwind states' ozone pollution, specifically Texas, and that it should have further evaluated its contributions by looking at its sources and its emissions. And it failed to do so. Therefore, EPA reasonably disapproved Mississippi's plan under its own terms. Just to address the updated modeling a little bit, because I have a bit of time, and it was raised by Mississippi. What the updated modeling did was simply confirm that Mississippi continues to contribute to downwind ozone pollution problems in Texas. The more refined the modeling gets, the better the data becomes, the more accurate it becomes. It continues to confirm that not only is Mississippi linked to one receptor in the Houston area, even just below the 1 ppb contribution threshold, but as it gets more refined, as the data gets better, it shows that Mississippi's contributions are greater than previously projected. From 2016 V2, which is the modeling that was considered a proposal, to the 2016 V3 modeling, which is the modeling that was considered at final and refined in response to comments, it becomes clearer and clearer that Mississippi's contributions to the Houston area are much more than previously estimated. And so it simply confirms that Mississippi should have further evaluated its contributions by evaluating its sources and emissions. The record support for that is provided on page 203 of our brief. It's a table and the record citations are in the footnotes. And so to sum up EPA's full position, EPA reasonably evaluated each state's SIP under its own terms. Each state's SIP, which used the best available tool for estimating ozone concentrations and contributions in the future, showed that it contributed to downwind ozone pollution problems. So all states covered in this approval, including Texas, Louisiana, and Mississippi here today, should have further evaluated its contributions. Their arguments for why their contributions were insignificant were technically unjustified or did not refute the photochemical grid modeling results under the version of modeling that they selected, and that as it got more refined with EPA's consideration of the updated modeling. And so there are multiple bases for upholding EPA's disapproval of the state plans here, and we ask that this court deny the petitions for review.
Before you sit down, your argument that you just made, you said you evaluated each state's SIP, correct? And it was, am I correct?
Yes.
Right, that you just said that. And it's an intensely factual determination of each state's SIP, correct?
I don't know. I don't remember
Well,
using the terms intentionally factual.
Where you didn't, but I'm saying,
okay.
it appears to me that it's an intensely factual determination. And on that point, and I'm going back to venue, it seems to me the EPA's position is inconsistent with each, I'm disapproving this state, and this state, as I get this as part of a national plan, but it seems to me under the case law, the majority of the case law, this would fit under those cases that say that the SIPs are prototypical, local, or regionally applicable actions.
Right, and so the nationwide scope or effect prong is the exception to those actions that are locally or regionally applicable. So there will be certain factual determinations that are local, but the disapproval is based on determinations of nationwide scope or effect, because all the reasons that were provided here in the petitioner's briefs for why their contributions were insignificant were not state specific.
Right, but going back to Texas's argument way at the beginning, the legal effect of the action affects each state. Am I right?
The legal effect of a SIP disapproval is that EPA has to implement a federal plan to meet the Clean Air Act goals.
Yeah,
Yes.
I want to go back to Louisiana for
Oh, yeah.
a minute here. They say that their actual data shows it's going down, whereas your model shows it's going up. Can you respond to that?
Right. So first, as an initial matter, I just wanted to reiterate that was first raised in Louisiana Industries' reply brief and was not raised in its opening brief, and respectfully asked the court to consider it waived. But secondly, addressing the merits of that argument, Louisiana commented to EPA, noting what its ozone precursor emissions and its contributions were in the comment period. EPA evaluated Louisiana's comment and then incorporated the reduced reduction, the more accurate reflection of Louisiana's ozone precursor emissions in the 2016 V3 modeling that was issued at final. The 2016 V3 modeling, but even with Louisiana's lower emissions, continues to confirm EPA's conclusion regarding Louisiana's own submission, that Louisiana contributes not significantly. Louisiana contributes a lot of ozone pollution to downwind states, or here, Houston and the Dallas area. As the modeling gets more refined and the data becomes more updated, which, as Louisiana Industry says, they have lower ozone precursor emissions, it still shows that not only does Louisiana continue to contribute, but contributes more than previously expected. Or previously projected. And so that's also provided on page 203 of our brief in that same chart.
Thank you.
Thank you, Your Honors.
Thank you, Your Honor. I want to take a moment to just make, I think, 2 or 3 main points, hopefully following up on some of the points raised in the questioning. First, I wanted to respond to this idea that EPA has raised about this is a collective contribution issue. It's not a collective contribution issue in the key sense that matters here, and that's that under the good neighbor provision, the key question is whether the state, the individual state at issue submitting the SIP, is contributing significantly to a downwind problem. So you can't sort of say like, hey, look, this involves another, a bunch of states, so therefore EPA kind of gets to make the call. The key question is, are you the state making a significant contribution? The DC Circuit in the North Carolina versus EPA case at pages 906 to 908 recognizes this kind of point that, hey, look, you go by state and you look, each state has to address its significant contribution. So the question really comes down to, is the state making a significant contribution here? And for all the reasons I said when I opened, the state made a very reasonable presentation on why it is not doing so. I didn't hear anything to overcome that, but I do think it raises, I think, a point that you were getting at, Judge Stewart, about, look, both sides claim they're reasonable, who sort of gets the claim of reasonableness in this context. The EPA would have a much better argument if we were in the sort of normal agency paradigm where you don't have the typical cooperative federalism where a state goes first and that sort of a thing. But we're in a very different world here with this sort of statute. We're in one where, in the worlds of the Alaska versus EPA case, the EPA is not in a world where it can second guess reasonable determinations that are reasonably moored to the statute. If it's a reasonable determination that's reasonably moored to the Clean Air Act provisions, and that shows up in different ways on pages 485 and 490 of that Alaska versus EPA decision, the EPA has to approve it. And I said it this way, kind of opening, primary in the statute and in this court's cases, it has to have real meaning. It can't just mean the state gets to go first and kind of make little decisions at the margins. Oh, we're going to run this engine and not that engine. And it certainly can't mean that the EPA just has independent, freewheeling review.
That's true, but the other side of it, it happens the 3 states here are contiguous. So, your numbers are good, but if the EPA is looking at the local data, but part of what's significant is particles that's coming from Texas, for example, or vice versa. And so if the state's looking at its view to say, well, our numbers are allowed, because I'm looking at Mississippi, for example, the EPA's job is, yeah, you're looking at Mississippi, but your determination of significance is not taking into account those particles that are affecting Texas, for example, or the other. I mean, it seems that that's part of the equation. That's not the national argument, but when it says as I understood him to say, he looked at Mississippi's numbers and looked at its determination, but its argument is that Mississippi's determination is, quote, in a vacuum, meaning a vacuum of looking only at the effect on Mississippi and not the broader, more holistic effect on others, which it says is its statutory charge to look there. So we've kind of got this.
Right, and I think that draws
seems to be somewhat their pushback to say not that they're not looking at the individual numbers, but that the state's response seems to discount, that's my word, discount the implications of the numbers vis-a-vis the adjacent states, the downwind stuff, and all of that. So it can't be the case. You get to grade your own paper and say, you take the test, but you get to grade your own paper, and I give myself a pass. I don't have to submit the paper, take his example.
Right,
I get this, a self-graded test. It's an oversimplification, but you understand.
I take your point, Judge Stewart. And here's what I think. I think that actually gets right to the point that I was hoping to hit home, is that we're not saying that all the EPA looks at is, did the state make a determination? Period, stop. We're saying, was the determination reasonable and reasonably explained? And look, if we had really high numbers and we didn't, we'd have a much bigger problem. But you look at the numbers we have, we explain them, we're reasonable. We're saying, look, one receptor barely above 1%. And I think to get to the kind of collective contribution point, the EPA itself is, of course, it's quite fond of a threshold point. It just, it likes the 1% threshold. It recognizes that it can't put that at a hard line. And all we're saying is that, if I may just finish up, Chief Judge Richman, all we're saying is that this is an area where the state gets to make a reasonable judgment on significance.
That's where I want to home. They say your 1 part per billion is not equivalent, materially not equivalent to their 1% standard. And that when you apply that test, that Mississippi does significantly contribute. And their overarching theme seems to be, well, it may be small, but when every state says, well, I'm reasonable and there's not a problem, but in the aggregate there is a problem, they can't let that stand.
Right. So
they can't let states say, well, I'm reasonable, and none of us we're not part of the problem.
Well, I think it's one thing, Chief Judge Richman, if you have a state, with a bunch of really high numbers, or like the example I brought up when I first stood up, which was, say that we were at 0.99 at a bunch of places, and you could see that we have to give more of an explanation to justify that, because I do appreciate the problem. But the question is, that we're saying under Alaska versus EPA and other cases is, are we reasonable? And, we've looked at the other, the EPA's own view of contribute. We've looked at how close these two thresholds are. I mean, we're quite a ways under 1 part per billion. At the one place we're over 1%. And we're just saying, like, hey, based on all the facts and the data available to us, based on a very reasonable view of the Clean Air Act, our determination is reasonable. If you were to see another state that had more challenging numbers, or just more connections, more sites, and just higher up, you may want to have to. I mean, again, they'd have to meet a reasonableness standard,
Well,
and
let's
that's what
say
we're
in
saying.
this case, you say your numbers are good, not you, but Mississippi, so let's assume arguendo, we don't have to come out the same way on all 3 states. Let's say in Mississippi, we say, okay, Mississippi was on target, the numbers don't seem to be significant in the definition, boom, King's X. On the other hand, looking at Louisiana, looking at Texas, Louisiana's got petrochemical plants, and whatever. Texas has got everything. So, the grading is a little bit different. So maybe Mississippi's argument, hey, we're good, we don't have this stands, but the EPA is similarly evaluating the 3 of them. But you see what I'm saying?
Right, but I think they are. You evaluate them on your own merits, Your Honor. I mean, each of the individual pool. But I think that's fair and that's right. And I mean, I think that fits into, frankly, I think the shared view on venue here, that each of these are individual disapprovals, and they each have to stand or fall on their own, even with overlapping themes.
The bottom line, I mean, we've got all this modeling in here, back trajectory, whatever. The granular scientific, it just strikes me the case is not going to turn on the 3 of us reading of all that data, but trying to stay with, where we are on the point you're making. And then this question of, if EPA's guidance is the, quote, preferred guidance, what does that mean? It's preferred, but it's not mandated, which I see the state saying it's a preferred guidance, but it's not mandated. So if it's not mandated, do they get to use their own? EPA says, well, no, you don't have to use the preferred, but if you use your own, you still can't just say it doesn't matter. That's where I see tension.
Right, and recognizing that I've gone over, Your Honor, I would say in our case, the 3 core things we looked to were the March 2018 memo and the modeling and data presented, the August 2018 memo on 1 part per billion, and then kind of the prevention of significant deterioration program. That guidance looked at all of that holistically, context of the Good Air Act, Clean Air Act, Good Neighbor provision. And I think the question, just looking at our SIP submission itself, it's not that many pages, happily in a case of many pages, and say, hey, look, this is reasonable, whatever it else is. It's reasonably moored in the Clean Air Act. It should have been approved. The disapproval should be vacated. Thank you, Your Honor.
Thank you. The case is under submission. The court will stand in recess until 9 a.m. in the morning.